Welcome to this presentation on important thing you should know about FOB contract. Today we will take apart the basic including buyer and seller duties, remedies in case a dispute arises, concrete law that regulate FOB contract and key case law that has been applied to FOB contract in the real world. Let get started. What is the FOB? Uh, Let us first look at what FOB means. FOB is a trade term that defines where the seller responsibilities end. In an FOB contract, the seller is no liability after goods are loaded onto the buyer nominated vessel at the point of shipment. Risk and ownership of the goods pass from the seller to buyer at this point. What it implies is that if any damages befalls the good subsequent the loading, the responsibility lies with the buyer. The transfer point of FOB contract is clearly outlined once to stay out the argument who should take the answerability, in which I will define the buyer duties. So, what are the buyer duties under the FOB contract? Buyer duties have three main responsibilities. Nominate vessels. There is a absolute requirement. Uh, there is absolutely requirement for the buyer nominate suitable vessel and to give prompt notice the detail to the seller. There is it so that the seller has the time to prepare for delivery, arrange marine insurance. Once goods are loaded onto the vessel, the buyer has a duty to ensure the marine there are then and cover the risk transit, handle freight and custom. The final responsibility of the buyer will be the paying of freight charges and ensuring that goods in questions and proper clear at the point of destination custom. Now I will define the seller duties. Next we will examine that the seller has to do. Seller are responsible for delivering goods. Goods shall be delivered by the seller to the prompt of shipment and shall be loaded. The buyer's selection of vessel, export of formalities, complete all the export related formalities such as custom clearance. It is the duty of seller. Shipment documents. The essential document must be given by the seller to the buyer to be provided with the clean bill of landing. This document is important because it is being used to confirm that goods have been sent to the state, uh, and in which the most important FOB contract is the insurance. FOB contract also involve very important element of insurance responsibility of the for the purchase of insurance. Once the goods are loaded onto the vessel, reset with the buyer. In extended FOB contract, seller, however, may take care of the freight and insurance arrangement. It is done. It is done to give the buyer a shield point if something does to do the plan, ensuring the buyer protect him from the loss due to damages or uh, lose during transit. Uh, Now I will discuss the remedies in FOB contract. And if something goes wrong, what happens? Remedies under the FOB contract are applicable with respect to the interests of the buyer and seller. Let us break it down. Buyer remedies: goods that do not conform to the contract term can be rejected by the buyer. In addition, they may sue for damages, late delivery for failure or failure to delivery, and the seller remedies. Seller remedies: in the event that buyer refuse to name a vessel or accept the goods, seller may claim damages. These remedies are fair and liable for both parties. Mm, Now I will discuss the legal framework and jurisdiction. Both national and international legal framework of FOB contract exist. In the UK, these are regulated by the Sale of Goods Act 1979 and Marine Insurance Act 1906. These statutes resolve the confusion as to the who and what bear risk transfer and insurance obligation. On the other national level, international dispute is settled by the United Nations Convention and Contract for the International Sale of Goods 1980, which provide a standardized way to the resolve dispute. The Hague-Visby rule also have application as to carriage by sea regulation obligation and carries under of FOB transaction. There are many case laws. I will discuss the case laws. Let us now turn to some key case laws that illustrate how to FOB contract and applies in practice. Biddle Brothers versus Calmont Horse in 1911. In this case, the fact that the buyer had the right to payment only after the shipment document were provided was affirmed. It is also bring out the need of good document in the FOB contract. Galaxy and Gree versus Marco Petroleum 2012. Here remedies available to the buyer in such case of delayed delivery were explained. Another, the most famous, Across Limited versus EA Ronason and Son 1933. This court thus upheld the buyer right to reject the goods if the good did not conform to the contractual specification. It is simply to know notion that all must be same agreed qualities. Now I will conclude my assignment. Finally, FOB contract are created to be able clarity cost responsibilities and risk of the buyer and seller by helping to structure the approach the management of international trade transaction. They help reduce uh, potential dispute, understanding what is the obligation, remedies, and its legal framework will make the possibilities of business better um, handle how to operate the FOB contract. Thank you for your attention. I hope this presentation has given you more clarity and they keep element of trading FOB contract. Thank you.